Okay, good morning, everybody. This is Michael Levitas here with business litigation attorney George Van Orr. How are you, George? Thanks for coming
I'm good,
on.
Michael. How are you?
Very good, thank you. Thank you. And George, you're part of the JurisQ Legal Network as our participating attorney doing commercial disputes, commercial litigation, all types of lawsuits. You're very knowledgeable in this area, and this is why I invited you to discuss the very, very interesting and newsworthy case, Theranos trial. The main character there, Liz Holmes, was just found guilty a few days ago. And I talked about this case earlier, actually a few months ago on my radio show, and got a lot of interest in the case because it's a one-of-a-kind case. Liz Holmes, the CEO of Theranos, she was the first self-made female billionaire under 30 years old. She was in her 20s when she was worth $5 billion, and the company was worth $9 billion. And the company, Theranos, what they did is they promised that they're going to take blood samples, and they have special machines to process the blood samples and show you exactly what disease you have in a matter of minutes or hours. Very convenient, very cheap. It was revolutionary. And based on that premise, she has raised billions of dollars from friends, family, and big investors from big companies. She even was accused of defrauding pharmacies like Safeway and others, promising them that her machines work, machines she's going to store in their pharmacies. They gave him also millions of dollars for this. Very loud case because it had sex, it had drugs, it didn't have rock and roll. But it had sex because she, in her trial, was trying to excuse her behavior, that she was manipulated by an older man that she was dating. Her second in command, Mr. Balvani. And he was also an investor. He gave her millions of dollars, but she held most of the stock. She had most of the voting rights. But they were lovers. He was maybe 20 years her older. And she was trying to claim in her trial that she was lying based on his manipulation. And as we see, it didn't work because she was found guilty. But George, correct me if I'm wrong, she was found not guilty of lying to customers, meaning the people who actually paid money for these tests, and they got false results. And some of these people were even cancer patients, and for them it was very important to get right results, which they didn't get. On those charges, she was not convicted. Do you have any idea, by the way, George, why you think on those charges she wasn't convicted? What was required to prove there?
Well, it was a crazy case that went on and on and on and on. And this all stems back from this company that this woman started apparently when she was like 19.
Right.
And, she was kind of a huge deal in Silicon Valley. And indeed, this company, the way I understand it, is that they promised to like take several droplets of blood, like very little blood, in order to assess all sorts of diseases. That's how I understand it. I'm no medical specialist, but and then so it's kind of like a panacea for like testing for diseases, right? So everybody got super excited about it. Obviously, people that want to ascertain, what their state of health is, or what they could potentially be exposed to, for them, it could be a huge deal. It could be indeed revolutionary for the healthcare industry. And healthcare, mind you, so you understand, it's like, I think it's a quarter of the American gross domestic product, right? So it's like some insane amount of money we're talking about as far as the industry.
Right.
So what she got charged with, and it was, by the way, a one indictment of her and her COO, Balvani. She got charged with violations of the wire fraud act and conspiracy. And there were all sorts of alleged misrepresentations that she was involved in. And I read the indictment the other day, and it kind of conflates everything into one. So to answer your question, it's not very clear exactly what happened in my view, because,
Right.
you know, one thing we have to be careful with all, due respect to Ms. Holmes, is that it was a 53-day trial. And
yeah, that's a long trial. For federal trial, that's a long
trial.
trial. Yeah, usually they are lightning fast.
One of the things that a lot of people have criticized about the trial is that there were a lot of delays. The jurors, kept asking for breaks. It took a while, and then it was kind of on and off and on and on. And they're saying that creates a greater chance that there were some mistakes. So we could very, very reasonably see some appeals coming. And Balwani's trial is about to start in February. So that's going to be interesting too, to see what happens there. But anyway, the way I see from the indictment is that the very important misrepresentations that are there that kind of just stand out is that they essentially misrepresented the alleged revenues of the company.
Exactly.
They said, look, we're going to make like some ridiculous amount of money next year.
Yeah, she promised investors in 2015 that they have sales of $1 billion next year. Right. In fact, she only made a few $100,000. So of course, when an investor sees that the company is about to make billions of dollars, they're going to run to invest. And we talked about this earlier with you. There's a concept called FOMO, fear of missing out.
That's right.
People are, with this hype around the product, around the company, people run to get that stock, to invest. And sometimes without doing proper due diligence. Due diligence is checking actually what's being promised, the financials, and so on. And also, she did a genius thing. She surrounded herself with big names. On her board, she had people like Henry Kissinger. She had General Mattis, Robert Murdoch, and the Walmart family. So of course, when you're an investor, right, and you see all these people on the board, you're thinking, these guys are very smart. They already checked the company. They're with her. I also want to be with her. They didn't do their own independent research. And that's there's a lot of lessons here to be learned for people who are investing not only in such big companies, but also smaller companies. And we're going to talk about that as well, that the same problems that facing when investing into a billion-dollar company, you can also face investing in a small mom and pop or into a store, a smaller business, same concepts apply.
Absolutely. But what I was impressed with or interested in with Elizabeth Holmes was the fact that she took the stand. And she, like a lot of criminal defendants, don't take the stand in defense of their own case.
Not advisable.
It's the prosecution that has the burden. But here, this woman took the stand for like 7 days. She was grilled, for 7 days, and she was trying to, defend herself and give the reasons. And it takes a lot of guts to do that. So there's a pretty gutsy move by both her and her legal team. And, they were able to fend off some of the charges, and, so in terms of the board, though, you're absolutely correct. They had some big names, and there's been some criticism of the fact that, the board failed to oversee what was really going on. So that's going to get interesting, too.
Yeah, and I surmise the reason why she went on the stand, because she wanted to portray herself as this young, vulnerable woman, didn't know what the hell she was doing, maybe cry a little bit on the stand, and show that she was manipulated by this older gentleman, Mr. Balwani, her older lover, and looks like the jury did not buy it. And maybe even that could have angered some of the jurors or the judge, that she was trying to use her younger age and her femininity almost to try to get an advantage.
This is where we cross paths between a layperson's perspective and kind of a lawyer's perspective. I, as a litigator, I don't judge, unless I'm there and I'm like there every day and I'm doing the case and I know all the facts, it's hard for me to say.
Yeah,
All I
nobody knows.
know, it's very, very difficult. But all I know is that, it was very complicated. There was a lot involved. And look, the prosecution has a burden of proof beyond a reasonable doubt, right? So unlike in a civil case, where it's just like slightly more preponderance of
Right.
the evidence. So I have to prove
Mhm.
that, it's more likely than not that, somebody did something wrong. The prosecution has to prove beyond a reasonable doubt. So
Mhm.
one of their strategies could have been that these 7 days of testimony would have created some doubt, right? That look, this woman, maybe she was, young and innocent and naive, and she didn't quite understand everything. But I tell you, it's hard to get around some of the allegations or facts that, if they were proven that, look, I'm going to make $1 billion, but you make a few $100,000. Like that's
Mhm.
a tough one.
Yeah. All right, George. Let's move on to more towards small businesses. I mean, we have a lot of viewers, our members on various of my platforms who are business owners. Let's give them some practical advice. You, as an attorney that does a lot of business litigation, you both sue companies and you defend companies and businesses from different lawsuits. So you see what's out there, what arises. I want to talk to you about some of the lessons we can learn from the Theranos case. And the first thing that comes to my mind is that dealing with investors, right? Investor, like we said before, could be you could be investing in a big company, or even if somebody's opening a small business, somebody's opening a store, some kind of online service, looking for investors. Investors could be your friends, your family, or others. Maybe they're making 50 grand investment. Maybe they're making $1 million investment. Talk to me about a little bit about what are some of the pitfalls to avoid when you're trying to attract investors into your business to avoid getting sued later on for fraud.
Sure. So, I've been practicing for 17 years in commercial litigation. And in addition to doing just cases involving these issues, I often work as general counsel for companies in that scenario. So I try to help them with structuring their contracts in order to avoid potential litigation.
Right.
So, there's a lot in your question. It depends a lot on the type of business. But so first of all, the big differentiation you have to make is it a private business or a company that you're going to take public to the Securities and Exchange Commission? It's going to trade.
Let's talk about smaller companies.
All right, small companies, private business. So there are various concepts in the law of what you could hypothetically get sued for, okay? And I'll try to translate some of them. First of all, you want to be truthful in the representations that you make. You can't make active misrepresentations.
Sure.
Because there are two issues there. One is what's called fraud and inducement, where you induce somebody to enter into a contract with you. And the example I gave you before, which I'll give again, is if I say to you, Michael, I'm writing this movie. It's really interesting. I already have deals lined up with HBO and Netflix and everything else. And you say to me, George, wow, you're my friend. That's amazing. So cool. Can I give you $1 million? And I say, sure. Thank you very much. We shake hands. That's kind of fraud in the inducement because I don't have any deals with Netflix, or HBO, or anything else, right? Now, it raises the question is, why did you trust me, right? Why did you trust? Why didn't you check that I had deals with Netflix and HBO? And that's called due diligence. So it's kind of on you also. There's a difference in the law between dealing with what's called sophisticated investors or accredited investors and just regular people. So let's talk about regular people. With regular people, you cannot make active misrepresentations. So when you're taking money from somebody, you have to be truthful about the circumstances that you're taking money for. It's also very important to have a very good contract when you're taking money, regardless of whether it's your relative or your friend or anybody else. You should have a contract which articulates specifically what are the funds for, what are the terms under which you're taking these funds, What are
what are the promises? Yeah.
What are the promises? What did you represent? What did you warrant? What didn't you represent or warrant? Now, the balance for lawyers often, right, is how to not mess up the deal, but at the same time protect the client. Because a lot of business people, even simple folk, they don't want to deal with any of this stuff. We're friends. We've sat in the restaurant. We want to make a deal, and we kind of want to trust each other and go.
Right.
And the approach for
that's a big mistake.
It's a big mistake, but it happens all the time, every day, all day long, right?
Right.
And I've done cases where contracts were signed on the back of the napkin. I've done cases where people disputed the signatures, that they said they never signed this document. But a good written contract, for example, is going to have something called an integration clause. And what
is that?
Okay, so that clause will say that, look, this contract includes everything that we talked about. We're not going to rely on anything that happened before. So me and you may have talked about Netflix or HBO or any of that stuff.
Right? Got it.
But here in this contract specifically says, I am not representing that I have any specific deals with Netflix or HBO. And that's what we're relying upon, that contract, right? So that's important. A lot of contracts don't have that. You also want to have like terms for repayment. What are the expectations? What is the person going to own shares? So there's a slew of questions that have to be asked, but it really comes down to, if you're soliciting money, you should be upfront about everything that's material. And that includes omitting facts. So it's one thing I actively told you, look, I have a deal with Netflix. So that's a lie. I don't have any deal with Netflix. The other, I didn't tell you about the fact that, I owe $30 million to somebody else, under this company.
And that's a material omission. That's a big fact that you should have disclosed to your potential investors.
Exactly. So, as part of the due diligence process, if I'm representing the investor, we'll check for that. And we'll try to check, are there any other lawsuits? Who are these people? What deals have they done before? What track record do they have? How successful have they been? Things like that.
And financials, you should probably get, at least audited financials of the company, or audited something from the accountant that shows the expenses, the income, cost of goods sold. And if you can't understand yourself, bring it to your own account, show it to them. They can explain to the numbers.
Yeah. So every case, Michael, has to be a balancing act between the, again, risk management of the particular situation. So if you're doing a deal for $100,000, we're not going to be doing $100,000 worth of due diligence, right?
Right.
We'll do enough due diligence to kind of protect the basis, right? The major facts, right? We'll ask for some representations in the contract to make sure that we're not getting screwed in something, right? So that's one way of dealing it. If you're doing a much bigger deal, let's say for $100 million, then you're going to be doing significantly more due diligence, and you're going to be asking for more reps and warranties. But what you'll be shocked is that I've done cases where even huge companies with $100 million deals have missed stuff in asset purchase agreements, where they didn't check the litigation history. They didn't know what the exposure was going to be for prospective litigation. So the next thing you know, I've done a case where there was an acquisition made, and then all of a sudden there were a whole bunch of lawsuits filed. And the company was exposed to this liability that you had to fight off these lawsuits. And it could have been prevented with proper due diligence before the case.
So the lesson learned is that, to interrupt, whenever you're investing into a business or you are taking on investors, you should have an attorney present, review materials, review what exactly are you showing to your potential investors, what numbers you're showing, what are you not showing. Don't just do things on a handshake, as some people like to do. Because then you're going to end up hiring somebody like you to litigate a dispute.
Absolutely. I mean, I can probably think of maybe one or two examples in my whole entire life where handshake deals worked.
Mhm.
You know, most of the time, most of the stories that I hear on a daily basis during a 17-year career are situations where, but I trusted that person. He was my, cousin, or he was my friend, or we had done so many other deals before. And, he told me X, Y, and Z, but that promised to be completely false. And he used the money for something else. Those stories are endless.
Exactly.
They happen
And
all the time.
and George, you know what's funny? When things are going well, things are going okay. When things turn sour and business is losing money, that's when you start having accusations. That's when you start having lawsuits. But also, when business is doing extremely well, there could also be problems because then one partner who be not happy, he's not getting as much as the other partner. I also want to make the same. So that's why it's important to always protect yourself with proper operating agreements, right, between partners and
Right.
between the investors.
You should, I think what the real role of a corporate attorney, good general counsel, is to reflect the intent of the parties with respect to their agreement and do it in a way that doesn't interfere with the deal, with the business. And that is really tough, so you kind of have to understand, the psychology and the business and the industry and everything else. You're going to deal with, movie people differently than you're going to deal with hedge fund people. They're just completely two different people. But if you come in and you understand that, look, basic concepts, we want clarity between us. Why do we want clarity? Because we don't want to fight. We don't want to fight. We want to make the business successful. How do we make the business successful? By having clear agreements which reduce the risk of prospective litigation. And not only between ourselves, but between us and everybody else. So whoever gives us money, we're going to have very clear agreements with them. What do we owe them? What do they owe us? And what is excluded from this particular agreement? Between us, we're going to have an agreement which specifies who is doing what, who is getting what, when, why, etc. And in the event that we have any disputes, then where are we going to resolve those disputes, how, and who's going to pay for it? Those are some basic things.
Yeah, that's very wise words to avoid litigation. It seems like when you're trying to attract investors, you should not be too optimistic. When you paint too rosy of a picture, it does not pan out. That's when you're going to have possibly problems down the road. You should be more conservative or more general in terms of what you promise. Would you say that's the case?
I would say that's the case. I also think it's wise to, the phrase, we're drinking our own Kool-Aid. You've ever heard that? So, sometimes, me and you may think that we're like geniuses that created, the next evolution in plasma physics,
Yeah.
But if we get an outside advisor who actually a physicist who comes in and says to us, listen, guys, no, you did not, right? That'd be useful for us to know. So sometimes getting a outside perspective on something is helpful. So you may want to just surround yourself with advisors that can give you an objective view, not just yes men, but people that can give you an objective view. And the best businessmen that I have seen have different people on their teams, Some are the yes men, some are the completely negative, like nothing is ever going to work.
People. Yeah, you need them both. It's true. It's true.
And if you have that team, which is, kind of balancing everything, then you come up with a product that ultimately makes sense. But I think that you should err on the side of caution. We live in a highly litigious society.
Exactly. So not just from a criminal standpoint, but also from a civil lawsuit. You're correct. Exactly right.
I was reading the indictment. I was thinking about it this morning, that the difference between the Wire Fraud Act and just regular, fraud in the inducement that you can get sued for civilly, it's not that drastic. I mean, it talks about, making misrepresentations and defrauding people. I was going to give you this example, so I'll show it to you because I pulled it out. So this, for example, is a book. which is the New Jersey causes of action. Okay.
That's a lot of causes.
So
How thick is this book?
650 pages long of just things that you could get sued for. Okay.
650 ways you could get sued in New Jersey.
No, not even ways. I mean, there's much more than 650 ways. It's 650 pages worth of ways that you can get sued. In New York, the jury instructions are 4 volumes long. So I have the book somewhere. I'll have to pull it out. It's literally this big. It's like probably 2,000-3,000.
That's why we let people like you, handle the cases for us.
All right. So let me read to you fraudulent concealment by fiduciary, which is kind of applicable here. So what is a fiduciary, first of all? Fiduciary is somebody who has a heightened duty of care. All right. Mm-hmm. So if me and you are strangers, I don't owe you anything except I shouldn't cause you harm. I can't punch you in the face. You can sue me for that.
Okay.
But if me and you enter into a business relationship, especially if I'm taking money from you and we're partners in the business, I become a fiduciary. I can't now lie to you. I have a duty of care. I have a duty of loyalty. I can't mislead you, things like that. So it says any party to a fiduciary relationship, which is Elizabeth Holmes, for example, and potentially and her, investors or, the company and its investors, a relationship of express or implicit trust and confidence, or an inherently fiduciary contract to transactions, investment contract, who intentionally conceals or fails to disclose a known material fact is liable to another party relying on the wrongdoer to his or her detriment for damages approximately caused. So what does that mean? If we have a contract...
Give it to me in layman's terms.
I'll tell you. So let's say me and you are partners in the business. You invested, $500,000. I promised you I'm going to work on the business. Mm-hmm. Me and you are fiduciaries as partners in the business. We should have a partnership agreement. We should have an agreement that documents what the terms are for your investment. What am I supposed to do? How many hours am I supposed to work? For how many years, etc. And we have a heightened duty of care. And neither you nor I can lie to one another. Mm-hmm. And we can't omit material facts because otherwise we'll be exposing each other, the business, etc., right, to prospective litigation. Mm-hmm. So that's just one example. I mean, there are myriad of other examples I can give you as far as, partnership disputes, litigations, breach of contract cases, etc.
By the way, I see now it's fashionable to call now fiduciaries all the stakeholders in the business. For example, even your employees, they're also stakeholders in your success because if your business goes belly up, they lose their jobs. So there is this, maybe it's not in the law, but it's like a social right now issue that whatever you're doing in business, you should think, who are you affecting? Who are the stakeholders? Your customers, society at large, employees, investors, and so on. So I think that's the right mindset.
Look, plaintiffs' attorneys, myself included, will find no shortage of ways to create new causes of action, prospective ways to sue companies. I mean, that's what we do. And, they're very creative, some people. And so the state of the law of what is the state of responsibility is constantly evolving. So what you just talked about, though, is also involving a whole new area of law that we didn't talk about, which is employment law and the relationship between employees and their employers.
And we'll definitely get to it. We'll definitely get to it.
So we can talk about that too. I mean, that's a tough one.
That's a whole separate seminar that we can do. Because labor law is a separate topic in of itself.
But look, I think the interesting scenario with what you just said, I can give you an example, is let's say that you have a tech company that's taking investment from people, right? And you have an employee, and that employee agreed to work for a particular rate for a particular period of time. But you promised this employee that they're going to be part of a stock option plan once the company goes public.
Yeah, you're right.
Right? Yep, and so that scenario, is kind of what we're talking about, right? Why did you promise that? Are you really going to have an IPO? What's the stock option going to be? Did you get an investment or didn't you? So all those questions pop up. So you're absolutely correct that you have to think about these issues not only with respect to partners and investors, but also with respect to the running and operations of your own business, interrelationship with vendors, things like that.
Yep. Okay, George, this was very informative. It was interesting for me, for you, and I'm sure for our viewers. And we're hopefully going to leave this up for other people to watch who didn't catch it live. And George, I think we should make it a habit once in a while. Let's go live and digest interesting cases, because these cases, you need an expert opinion, somebody who deals with such issues every day, like yourself. If we see anything newsworthy, interesting, sexy, let's. I'm going to try to invite you if you're available, and we'll discuss it. And then, most importantly, let's see how we can apply the lessons to everyday life of a small business owner, of a partner, employees, people who are, creating things, doing things, who are in business. There's so many things you have to worry about, not just running your business from a business perspective, but also how to protect yourself legally from criminal and from civil liability. So, George, once again, thank you for your time. Came out to us on Zoom on this snowing day, and I look forward to seeing you again.
Me too. Thanks a lot, Michael. Look forward.
Yeah, and if everybody has any questions, please drop them in the comments below. And if George has time, hopefully George can answer. So press like, share, drop comments, and we'll talk to you next time. Thank you. Have a good day. Have a good weekend.
Have a good weekend, everybody.
Thank you, everybody.
Take care.
Bye.
Bye.
Bye.